And the first thing we want to point out, a lot of times, well, there's, in this regard, two types of experts. There's consulting, there's testifying. Now, you can engage a consulting expert before the mediation to just look at the stuff and provide analysis, assist with the strengths and weaknesses. And opposing experts work as well, and you don't have to tell the other side you've got an expert working on it at this point. It's only when you get to where you're disclosing experts for trial that you need to let them know about us. But these are all things that you can get from your consulting expert without ever telling them anybody that you've engaged us. So next slide. Then the testifying experts you bring in closer to trial. In addition to the services that were on that previous slide, you'd provide opinions, reports, and testimony, which you may not do as a consulting expert. You're more informal. Your opinions are more informal. And then, of course, at that point, you need to be disclosed, or when you're approaching trial or arbitration or whatever, you're going to have to tell them that you've got us now. But as a consulting expert, you don't have to disclose us, which is the primary advantage.
Oftentimes we see getting engaged as a consulting expert. Obviously, if there's a time situation, maybe where, for whatever reason, you need, as an attorney, you need help on something. There's not enough time for us to deal with it, so you hire some consulting expert to maybe help respond to the other side's expert. And we don't put a report together because there's no time, but we just kind of work kind of very high level from there. And then the other kind of time that I sometimes see it is if you have a dispute where your position is there are no damages, like there's nothing to respond to. You get an expert report and you're like, it's just total crap, it's just total junk, and we don't need an expert to respond to this. The client maybe doesn't want to incur the fees, so you'll engage us as a consulting expert to help deal with the deposition and kind of just pick it apart that way.
Or mediation. On the divorce side, sometimes we get called by an attorney who's at a mediation and needs us to look at something or value a pension or something, and to the extent that someone on our team has the free time, we'll do it. Just call us.
Yeah, so this is just kind of FYI. I didn't intend to pull this up, but these are kind of good resources. It's not really authoritative, but if you're dealing with experts, your experts should have some awareness of this. It might come out in a deposition, just asking random questions about it, but these are just good sources that financial experts should have some awareness of it. You should be able to ask them to provide you a copy of it, and if they can't, that's probably a problem, right? Especially if you're a CPA.
And again, yeah, these are AICPA standards. We're not all CPAs, but on the business lit side, they are all CPAs. So this particularly applies to them.
Yeah, and it's riveting reading, as you would expect.
Yeah,
right?
that's
just a good thing to be aware of.
Pop quiz. You received a business valuation report 2 days before mediation. Need someone to assess it and critique it prior to mediation. What kind of expert do you need? Anyone? Hey, good job, Dan. You can just call somebody to be a consulting expert. You don't have to tell the other side you've got them. We did that. Would you be? Go back.
Sorry.
Would you be able to use the same expert for mediation and trial if it goes that far? Of course you would, and you just have to disclose them. So this is when you're choosing your expert, these are some things that you probably are aware of. But first of all, you want to make sure your expert's qualified to give the testimony that you'll need. Have they testified before? And this is an important question. Have they ever not been qualified? Because you don't want to have to answer that question in court if you have been not qualified in another court. And then, of course, you want to be familiar with the Daubert criteria, because sometimes we get challenged, almost never get knocked out on Daubert. We're all well qualified, but you need to know the criteria.
Yeah, on the commercial side, we see a lot of Daubert motions. It just kind of seems to be something that's occurring with increasing frequency for whatever reason.
Go ahead.
Go ahead. So credentials, relevant credentials, there's a whole world of credentials, right? The big ones, as I see it, from my side, commercial is going to be the CPA, right? And, you know, most of our group, I think all of us have it, at least at the testifying level. And then, you know, there's a whole host of kind of other relevant ones that are related to forensics or they're related to valuation. They're usually put on by the AICPA or the Appraisal Foundation or NACFA. So those would be ABV, Accredited Business Valuation, Certified in Financial Forensics. Those are both through the AICPA. ASA, so that's Accredited Senior Appraiser, that's through the Appraisal Foundation. And then Certified Valuation Analyst. And then Steve, you can speak to the divorce specific ones.
Yeah, CDFA, Certified Divorce Financial Analyst, CFE, a lot of us have Certified Fraud Examiner. These are the letters behind our names, and I mean, I don't even include them all, there's so many of them. But the important ones are when you're talking about somebody's giving testimony about a business valuation, that you need to know what certification they have. And as Alan said, that there's ones that are given by the CP, like the AICPA, and then there's, like for example, I have a Certified Valuation Analyst, which is an ACVA, NACVA, that's the one you just mentioned. You should have one of them, but you don't have to have them all. And as long as you can establish that you have experience and you're qualified to give the testimony, you don't really need them, but it does sort of shortcut things when you have it.
I mean, it used to be like certain of them, particularly the ACPA ones, you had to be a CPA to be able to get it. That's not the case anymore, but they all require tests and some level of experience to be able to get them. They're varying degrees of kind of pain in the butt to get, but definitely worth it.
Free of conflicts and available. This is just sort of a logistical point, but you got to pay attention, because if you're hiring somebody, I mean, I had a case today where the attorney that hired me realized that the specially set trial was in October and she's going to be out of the country. She had to give the case to someone else. And you just, well, that was the attorney. I'm available for the specially set trial. But you got to make sure that they're available, or you're going to, you know, you get a week before trial and realize they're not going to be there. It's just something to keep in mind.
Yeah, and then likewise, you know, adequate staff is the expert. If you have a case that is data intensive, right, you need kind of boots on the ground to deal with it. You know, is it a one-man shop? You know, is it a larger firm that can, you know, pull people in from all over the country? Or, you know, it's like IAG where we have a pretty good, you know, ability to staff things.
You know, I kind of glossed over conflicts. And it's a pretty small community of whatever type of expert you need. They're going to pretty much know each other. And I've heard of things happening where, you know, an attorney might you spend the morning calling every expert in Atlanta and talking to them about the case so that the other side can't get them. Have you ever heard of this actually happening in real life, or is that just something that we hear about? You guys ever heard of that happening?
I've heard it for attorneys.
Yeah. Oh, okay, sure.
It's a real thing for attorneys. Conflicting out.
Okay, yeah. The same with us. If you talk to us about a case, the other side can't hire us. So just be aware of that too. Onward. We just wanted to outline from our perspective the role of the attorneys in our interaction with you. You're going to tell us what the scope of work is going to be. You're going to need to make sure, and well, it's just important for us to know specifically what we're working on, and we're not coloring outside the lines.
Yeah, and I would say that, you know, some of this there's a huge difference between kind of the family law side and my side in terms of kind of the interaction with the client and just kind of the role of the attorney. I kind of, almost universally, you know, I don't want to talk to the client. I certainly don't want to talk to the client by myself. I don't want to make a request of the client, you know, without the attorney being aware. You know, I certainly don't want to talk to the opposing expert. And I've kind of just observed that can be, you know, a huge difference in the family law, that is not only not frowned upon, but kind of openly embraced. So
we are frequently encouraged to communicate with the opposing experts to try and, you know, narrow the issues. If we can, you know, narrow the scopes or narrow the issues so that they can focus on that instead of whatever else they've been doing on. We are frequently encouraged to do that.
Yeah, I mean that concept of privilege, we take it, you know, pretty seriously, where we just really want to not cause more problems for anyone.
There's more rules on their side,
Yes.
and they enforce them. Not like
More guidelines.
Yeah, so kind of the role of the attorney as I see it is, I want to talk to the attorney before I start something. I want to make sure they have a handle on kind of what we're going to be, kind of the output of what we're going to be doing. It's going to be helpful to them. You know, I want to understand what documents that are going to be available, and you know, sometimes that maybe can be obtained by talking to the client, you know, initially, but just not really at the same time. You really just need to be kind of in lockstep with counsel to make sure you're not causing problems again. Yeah, and then just this communicate expectations regarding timing, you know, to make sure everyone's on the same page on deadlines. You know, just because discovery ends, expert discovery ends at, you know, June 30th, you know, does that mean all depositions have to be taken by June 30th? Because if so, that means your report needs to be done at some point prior to that, so there's time to kind of coordinate depositions. And yeah, managing clients' expectations, again, that's a good reason to just call the attorneys. You don't have to drop any bombs on anyone. Yeah, privilege.
Chiming in on the privilege piece, this may just be because Steve and I are both attorneys and have a legal background. We do, even on the divorce side though, work very hard to ensure that the clients are aware of privilege. So we tell them, never email us without the attorney being copied. So we say that up front. We also, I'm sure Steve probably does the same thing as I do, when somebody comes with their dad or their sister, we make sure that they understand, you know, with that person in the room, you know, this conversation may not be privileged. We tend to let the attorney, you know, say that. We do bring it up and make sure that they're very aware of any communications. If you send us something, your attorney's not on it, there's no privilege. So we do, it's a little more lax than in, you know, Allan's side, but we do still work very hard to ensure there's privilege. And if they send us an email and you guys aren't copied on it, we reply back, copy you in. So we do never have communications without you guys being aware or knowing what's going on. Even if we're having a meeting, maybe without you guys, because you say, yeah, I don't need to be there, we would still make sure you guys know what happened in that meeting, what was said, and that anything we told your client is not legal advice, and we made sure they knew that, so.
Yeah, and in general, kind of best practices for me is, you know, we don't like emails. So I'm not going to be emailing anyone. I'll generally pick up the phone. Just easier that way.
And yeah, particularly in business valuations in a divorce setting, one of the last things we do is conduct a management interview. We want to talk to the principal of the company and get all our questions answered and hear from them the questions that we have. We're frequently allowed to do that, you know, with the opposing party and no attorneys there. So it's kind of the Wild West in the divorce. You can do whatever you want. But of course, I got to have the attorney's permission to do that, both attorneys' permission, but we frequently get it, frequently meet with the opposing party about their business without attorneys there. So it's, as Allan says, a different world.
I can't remember a single instance.
This never happened. Yep. We're just listing the types of engagements that we're frequently involved in. Divorce down to here, and then we don't really get involved in damages as much.
Yeah, I mean, in business valuation can be applicable to both, and it can also be applicable to non-litigated stuff, right? You know, there's tax-related valuations, financial reporting. We do get involved in that as well, but not as much as the litigation side. And similar approaches, similar everything, just a different context, and generally no attorneys yelling at you at the end of the day.
Any thoughts? In our world, yes, the attorney needs to sign the engagement letter because privilege. If the attorney isn't part of the engagement, then that engagement and the communications aren't privileged between us and the client.
Sometimes we get pushed back. People don't read through the engagement letter. We're not asking the attorney to sign because they're responsible for the fees. It's the privilege part.
Yeah. The client's always responsible for paying the fees.
I obviously didn't read the slide before.
So we've just been talking about the engagement letter, and ours is not 5 pages. I don't know that anybody's ever read it all except for the people that drafted it. I'm kidding. We read it. I don't know if the clients that read it, but it's all in there if they choose to. It spells out the terms of the engagement, scope of work, and pricing. Again, both attorney and client sign, client pays. This is something I added just because so many times the attorney contacts us and wants to engage us, and then it just dies on the vine. We don't hear anything. They don't hear from the client, and that's where the clients tend to drag their feet, because once you sign the engagement letter, then you got to pay the retainer, and there's always just a dead zone at that time. And unfortunately, the attorneys are always trying to. I mean, we go into it a little bit later. It's always best to engage us as quickly as possible so we can help you with discovery, and we have time to do our analysis and a whole bunch of reasons we're going to talk about in a few more slides. But the clients don't see that, and they don't know that. I mean, that last week, an attorney was trying to get his client to hire me since February, and the mediation was last Monday. And the guy emailed me at 6 o'clock Sunday night saying, "I just paid your retainer." What do you expect me to do? I mean, anyway, we were able to help him a little, but it would have been a whole lot helpful. Even a week ahead of their mediation would have been a lot better than 12 hours. Anyway, just a war story.
And one thing too, on the retainers that I've noticed often is, I think attorneys will they'll have a retainer paid to them, they burn through the retainer, the client refreshes the retainer, and that's just maybe how it works. Maybe on a short engagement anyways. For us, we tend to hold the retainer to the end of the engagement, and a lot of times the client doesn't fully understand that. They pay us a $10,000 retainer. Our retainers are a lot bigger than on the family side, but they'll pay us this $10,000 retainer, and then 2 weeks later get hit for a bill for another $10,000, and they don't understand that we're holding the retainer to the end.
You know why they don't understand? They didn't read the engagement letter.
Yeah, no, that's right. And the very specific reason that we hold that to the end is it's not so much that we're worried that we're not getting paid. It's more if we're sitting at trial and we've got a $20,000 bill outstanding, if the opposing counsel's likely going to realize that because they're going to subpoena our invoices, and they're going to make a big deal about is the payment of these fees contingent upon the outcome of this litigation. And it's just kind of a bad one. So we always hold the retainer. We try to kind of keep the outstanding balance within that, kind of for that specific reason.
And just for the family law attorneys in here, he's talking about $10,000 retainers. Our typical retainer is $5,000, but as if you need somebody to look at a Thomas analysis or a pension, call us. We can do things for like a la carte for a lot less. I mean, we'll do pension valuation for $500. Our minimum charge is usually $1,000, but it's not cast in stone. So if you don't be afraid of the retainer, in other words, if you've got a smaller engagement, you just need somebody to jump on something, turn it around quickly, we can do it for less than that. I promise you. Just a little plug for us.
Yeah, nice thing about a small firm too is we have flexibility on that kind of stuff. Whereas when you're at a larger firm, it might be a little bit more kind of hard and fast what fees and retainers have to be.
We have a lot of autonomy, with regard to managing our own clients and work.
Okay, so document requests. I think for the family law side, Steve will correct me if I'm wrong, there's often a lot of very standardized things that are requested. So, we have templates, we've asked for stuff before, we have very specific wording for certain requests that have yielded results in the past. For me, a lot of times things are a little more facts and circumstances, kind of case specific. I don't necessarily have templates, but I think the point of this though is, we're able to help with this. We know kind of at least from the financial side what we need. And I guess getting back to this concept of getting us involved early, if we're not involved early enough, we can't get the documents we need, so.
And as family law attorneys know, the discovery is very standardized at the beginning. And we have templates for document requests for personal documents, for business-related documents. We can provide you language for your subpoenas going to the financial institutions. We've just implemented 8 bullet point request for crypto. In case somebody has crypto, we know what to ask for in order to trace it. We've we've got a lot of templates, and we're happy to share this language with you if you need it.
Interrogatories, we oftentimes have very specific questions and that can help guide us as far as information to request. So, we can help with that. Fact depositions, and expert depositions, I guess, but, we love getting involved in, if we have an opposing expert, we love drafting deposition questions to kind of pick apart that analysis and guide, counsel with putting that deposition on. And, a lot of times, a lot of attorneys that we work with are pretty astute. They know, accounting stuff. They know kind of generally what they're dealing with, but there's a lot of kind of nuance in things and a lot of dots that can be connected, and getting our help with that, I think, is often very beneficial. We can attend the depositions, that kind of depends kind of on, where we're at with disclosure maybe, and the parties agree to it. I'm not really sure of all the kind of specifics, but I have attended depositions, and the benefit to that, of course, is kind of calling, BS basically if the expert is saying something that doesn't add up. It might not entirely make sense to the attorney as to why it doesn't add up, but we can kind of pull them aside and say, that doesn't make sense, or here's the follow-up question.
We haven't really stopped and asked for questions. Are you guys good? Does anybody have any questions at this point? Because we're happy to, make this a more interactive process if you'd like. Just checking, huh?
Everyone wants to go home early.
Oh, yeah, it looks like you might get your wish. So, and this again is much more prevalent on my side than Allan's. We communicate with opposing experts informally to identify financial issues, and we'll even exchange documents. Experts frequently exchange documents that have been provided to them by their respective sides. And we, the goal is, of course, to try and stipulate to as much as possible, so a few areas need to be litigated. And we're trying to keep the costs down. We're trying to keep, litigation, frankly, to a minimum. We say litigated, but those we can narrow those issues in a mediation setting or just settlement discussions as well. It really does help when we're able to communicate directly with the opposing expert. And 9 times out of 10 in the family law world, we're allowed to do that. I understand it's a different world where Allan lives.
Yeah, the affidavits for discovery disputes, I think I see that most frequently. A lot of times we're fighting over direct access to the QuickBooks file. No one ever wants us to give us access to the QuickBooks file. So we write an affidavit and say, here's why, here's how it'll help, and let the attorneys fight it out from there.
That is one thing we very much have in common. We are always asking for the QuickBooks file, and we have a list of things that we can accept in the alternative, and that's what they always want to give us. And they never give us what we want, and it's always a fight, and we frequently have to do affidavits and go sometimes even testify in these motions to compel and whatnot about why we need it. And oftentimes things that we ask for in the alternative are frankly like a general ledger. Love it to be in Excel. They never give it to us in Excel. It's always a PDF, and it's always 500 pages, and it's like, it really would be more cost effective to just let us see the stinking accounting file. And they don't want us. I don't know what they think we're going to do. We're not going to, we couldn't change it. They give us a copy of a file. We can't change your, anyway. It's hotspot. So, we did have, I don't know if you've noticed when we've gone through this, it's the process. We start with the engagement, we move forward to discovery and how we can help there, and then here is where we live, the analysis, the actual accounting analysis that we do once we get all our documents and access to the QuickBooks file and all that. And these are the things that, like I said, the attorney's going to tell us what the scope of work is, and maybe we'll suggest some things, but in general, the scope of work is outlined by the attorney. And in the divorce world, it's marital balance sheet, separate property tracing, income and spending analysis, business valuation, and pension valuation. Did you have something, Diane?
Yeah, I have a question. Marital balance sheet, are you guys using family law software, that software for the marital balance sheets?
We do not, and I don't. Do you, Elizabeth?
No.
Would-
No, you use
Emily
a
would be
different
our.
software? So it doesn't help for us to like send you our family law software or our marital balance sheet or?
We would love to see your marital balance sheet just to make sure that, you know, we have the same data and backup documents that you have.
Okay.
Would you think that it would be helpful or beneficial for us to use family law software for the marital balance sheet?
Are you guys familiar with it, that software? Yeah.
Emily has been the one who kind of in the past has used FLS a little bit more than the rest of us. I think you've looked into it.
We use it more for, like projections.
After tax or more, projections down, like 10 years down the road, you know, wife's gonna be, ex-wife will be making this much, husband makes this much. You know, what's the difference in, you know, 10 years down the road, what are their assets gonna look like? Are they able to sustain this spending?
Yeah, we've also used it for tax kind of estimates and trying to figure out what somebody's tax is going to be if they can switch to head of household or when their, you know, deductions are going to be cut because of, you know, shifting of income and assets.
So are you just doing your marital balance sheet in Excel?
Yes.
It's easier for us to use that because we like to do various scenarios when we're talking about,
Proposed divisions.
yeah, proposed divisions.
Like particularly in mediation, we'll get a proposal from the other side and we can put it on our own spreadsheet and show what the side by side, this is the offer, what's she getting, what's he getting, what's the difference. And another place that we're able to help with a lot is apples to apples on the marital balance sheet. I mean, you don't want to give somebody all the investment money and somebody else all the retirement money because that retirement money is pre-tax. You want to make sure that you're splitting, particularly the retirement money, split that to make sure they both get, you know, reasonable amount of retirement. And then the other thing that comes up is pension valuation, which pension valuation people do use the family law software frequently for. The pension valuation is a present value of future payments that they're going to get till the end of their life, and we can do those present values. They're never right because we're relying on statistics to estimate how long they're going to live, and we're relying on the 20-year T-bill rate for the interest rates, which we know they're going to change. So that's another thing that you don't want one person to get the $1.5 million 401k and the other person, well, the present value of the pension payments is 1.5, so just split that. That doesn't work because the 401k, that money's in there and it can get passed on. The pension, if the person dies at 65, there's no more benefit and it's not apples to apples. So we frequently don't put the pension up in the body of the marital balance sheet where it can be divided like dollar for dollar with other assets because it shouldn't be. It's much more speculative, and we would usually, the best way to do it is to split the payments when they come. But people don't want to be dealing with this spouse for the rest of their lives, and I understand that. So when we do have to like sort of offset it with another asset, we will take a discount. We'll take the present value of the pension and then discount it by 20, 25, 30% just because of the speculative nature of it. And then you can sort of, whoever gets the pension, somebody else gets something else that's not dollar for dollar. Anyway, I got off track there. That's what we do in divorce. Alan's going to talk about their analyses in commercial litigation.
Yeah, I mean, it's, what is that, 5 things. I mean, these are all vastly different analysis, and frankly, you know, at least for damages, shareholders' abuse, fraud, I mean, every analysis is different. It's very facts and circumstances. So it's a little bit difficult to kind of broadly speak to kind of what those are going to look like, but it all involves, you know, the documents that we've kind of just been discussing. It likely is going to involve some of the bank records process that Shar spoke to. It absolutely is going to involve kind of understanding what records that we have, which is that document index that we showed. Because oftentimes, we don't get into this, but if we've got, you know, the bank statements, and bank statements are great, but it doesn't show you all the detail behind the transactions. So, you know, knowing that we have the check detail, the deposit detail, wire transfer detail is helpful. And those are all, can be very applicable to, you know, a number of these, especially, you know, the fraud if we're doing kind of a records reconstruction. And so sources and uses, you know, again, that's we already kind of went over that, but that's very applicable to kind of what we're doing. Okay, so I think this is probably me. Written reports, it largely is driven venue. I mean, if we're in federal court, there's very specific reporting requirements, Rule 26 reports. Other than that, there's not really a requirement that we produce a written report. I've had attorneys say, I don't want any report, and I don't know really what their motivation behind that is. It likely is more cost on the client because these things are expensive. But, from my perspective, at minimum, we need to have schedules. And the reason that we need to have schedules is it's going to help me in deposition. And a trial, remember, is what I did. Written reports are great, but they're very time consuming, expensive, right, for the client. And there's obviously a lot more you have to deal with when you have a written report. But, again, they can be helpful for us when it comes time to be deposed and testify about, what can be very complicated kind of issues, and done often far in the past from when you're going through a trial or, maybe even a deposition.
Written reports are much more rare in the family law world. And when Alan says schedules, you guys aren't accountants, maybe you know this, maybe you don't. We're talking about like worksheets, our work product that comes, usually it's on an Excel spreadsheet or something. We refer to everything as schedules, and schedule means it's different in your world than it does with us. But that's what he's talking about, our worksheets, our work papers, the stuff that we produce from our analysis. And it's the same in our business valuations. I mean, there's companies out there, you hire them to do a business valuation, they're going to charge you $30,000, and you're going to get a 60-page report. A lot of it's probably boilerplate language or macroeconomic analysis that the judge doesn't care about in a family law case.
Some of that can be driven off of requirements by state, I think.
Right. The requirements are totally different. In family law, judges don't want to see a 50-page report. They want us to tell them what the number is, and then why that number is reasonable. And that's what our goal is. We're certainly happy to provide our worksheets and then be prepared to testify or go into mediation and explain to the mediator why my number is right. And that's what our focus is, much more than producing a report that nobody's ever going to read.
Yeah. Often if you see a valuation report that's 60 plus pages long, it maybe has originations as a tax-related valuation, or at minimum they're kind of following the guidance, and it's Revenue Ruling 5960 is what guides a lot of those. It has very kind of specific things that you have to consider and document in the report. And like Steve said, a lot of it's kind of boilerplate. It doesn't mean we don't read through it and kind of understand it, but it's not necessarily narrative that's drafted by us. It's referenced from other sources, but it's addressing very specific requirements that the IRS has.
And he mentioned things we have to consider. Like any of us that do business valuations have a set of professional standards that we have to adhere to, and there are things we have to consider. And in these reports, they're going to write out, I considered this, but didn't put any weight on it because. And we also have to consider things, but we're not going to, we're just ready to answer that question. We don't have to write it all out, in other words. And it's a lot less expensive. I mean, business valuations can cost you, $30,000, $40,000 or closer to 5 or 10 for us. So, and that's, don't quote me. Depending on how hard it is to get the documents we need and the analysis and everything, it can be more than that. But typically, if we get the documents we need and it's not, a run-of-the-mill business valuation would be in that range, $5,000 to $10,000.
Yeah, I mean, it also too the complexity of the subject too. So that can really drive it. Okay. So expert depositions. I think this is probably applicable to both sides of the house here. For me, it's not. I mean, I think most of us don't particularly enjoy depositions. It's not fun. I don't know if the attorneys glean any pleasure out of it, but it's not enjoyable. And yeah, but it is kind of the culmination of our work. I mean, that's what kind of separates us from other accountants, because there's other accountants that have specializations in, for instance, business valuation. and they spend their day either doing reports for the IRS, which is narrative. Maybe in 5 years they get a call from the IRS and say, hey, we have some questions about this, and they have to sit down with an IRS agent. Or they're doing it for financial reporting, which means they're likely to have to deal with the auditors. But what separates us is we have to be able to kind of communicate, not just written. So the deposition, the trial is kind of where we have to do that.
And what particular strength I think most of the people that work for IAG have is we are able to look you in the eye and speak. I have this joke that I used to tell because I used to be a lawyer. People would make lawyer jokes. And I had one joke that worked for engineers or doctors or scientists or accountants. And the joke is, how can you tell an extroverted accountant? He stares at your shoes when he's talking. And we're all pretty good at communicating our ideas and not maybe a little better than your average accountant. But the other thing I want to tell you about depositions is that I worked for insurance defense when I was practicing law. I've taken more depositions than you can imagine, and I got to the point where I knew when I walked in the room if this guy's going to lie to me or not. You can just tell. You stick your hand out, and he's like shaking your hand, and he's staring at his shoes. It's like, never mind. We can help you with deposition questions. We've done it. A lot of us have a lot of experience. Elizabeth practiced family law before this, so. Yeah, I mean, it's always best if we can go there and see the answers and then, help write the follow-up questions, but that's not always an option. It costs money to have us there, obviously, but just so you know, we're always willing to help draft questions and attend if necessary, or call us during the break and say, he said this, what should I ask? And then we'll tell you what to ask.
It can also be helpful to have us there if there's a timing situation where if there's a deposition on Monday and our report is due Wednesday, there's no time, and this would be more for a fact witness, but there's no time for a transcript to come our way.
Right.
Necessarily want to rely upon the attorney to kind of communicate everything to us. So if we can sit there and listen, see if there's anything relevant to what we have going on, it can just make the process a little more efficient.
Oh, by the way, moving towards resolution, we did our analysis, and now we're moving towards potential settlement and trial. That's the stage we're at. So getting towards the end. If anybody has any questions, we need to fill some time.
Next slide.
Huh?
Next slide.
Yep. So moving towards resolution. Mediation. This is, in family law, we really like mediations. We want to be there. We want to help. We'll have our marital balance sheet up in real time. We can update it with new stuff they bring in. We can put the proposed divisions side by side. This is really where we do some of our best work, and we want the case to settle. We don't want anybody to have to go have a judge or jury decide how to divide their property. So we're always working towards getting a resolution. And again, family law, it's the best chance for settlement prior to trial. It's an opportunity to explain our analysis and the issues that we've encountered and why our numbers are the right numbers. We can update the stuff on the fly, and we can show you exactly how the other offers will play out. I mean, are they offering us apples to apples? Is this really a 60-40, or are some of the assets tax affected, others aren't? It's just, we can be there to help you through all of that.
So yeah, on my side, I personally don't have as much involvement in mediations. I've attended one, where I did kind of have the mediator directly ask me questions. And ironically, it wasn't even a case that I was going to be the testifying expert on. I had availability that day, and I wasn't expecting it. Oftentimes we know what's going on. Sometimes I'll get asked, where you think you're going to land on a specific number, so they have it going into the mediation. But I've found that a lot of times we are not even close to having our analysis, our work done before they mediate things.
Things do change after mediation. You get new information all the time. It's often, as most of you probably know, sometimes it's not even, people aren't even there to settle, they're there to get another round of discovery. So we understand that sometimes the case just isn't ready. And maybe it won't settle on the first try, maybe you gotta try again, or maybe the people just wanna go straight to trial. But the one thing, I always know more at the end of a day of mediation than I knew when I got there in the morning. So the issues will be narrower. The distance between the parties will be narrower at the end of the mediation day. So it's always helpful. I always encourage people to try to mediate as much as they're willing to before they put it in front of a judge, but that's just how I feel about it. So, getting to the end, trial, and there are arbitrations too. We've testified in arbitrations as well. The rules for evidence tend to be a little bit more relaxed in arbitrations. So when I was practicing, I loved it. You could always get the arbitrator to look at the picture you wanted them to see. But in this context, of course, we've already talked about deposition questions. We draft, most of us, 99% of the time, we'll draft, unless the attorney would rather do it, we will draft our own direct exams. We'll make ourselves available to practice the questions with you, although attorneys don't usually have time to do that.
Please give us the time to do that, though.
We would really rather have a run through, so we're not, it's always best to just run through it once or twice.
It can come off the rails quick if the attorney doesn't really doesn't know what you're going to say to certain questions, and they just throw kind of things that, maybe are irrelevant because of something that happened the day before in trial. You don't know what's going on, and just,
Anticipate topics for redirect. Now, I've got a story about that because I was in the witness stand. Somebody asked a question about our market data and evaluation. Like, is any of that market data from, like, these are transactions where a business has been bought or sold. And we get them from these databases, and it tells us where the company was located and how much it sold for and all sorts of data about them. We use them to estimate what this company might be worth. And they asked me about, was any of that data from North Georgia? And I said, I don't know off the top of my head. I'm happy to check for you. Oh, no, don't bother. That's fine. The answer should have been, let me check for you, because what he did was didn't let me check, and then he just came back on his closing statement and said, that expert wasn't even familiar with his market data. And unfortunately, the attorney, who had not practiced even a single minute with me during the beginning of this, or during the lead up to the trial, didn't know what I was going to say, so she didn't redirect me. And they just left it hanging out there, and it didn't work out very well. Definitely encourage you to spend some time with your expert, if there's time available, to make sure you've run through it a couple times and anticipate what you can.
And I think also, we generally have a pretty good idea of what the weaknesses are, both in kind of what we've done, because pretty much everything we do, you have to make certain assumptions, and we, coming out of a deposition, likely can kind of feel out possibly where things are going, and if we're not given the opportunity to kind of help craft the direct and make sure the attorney really understands the significance of things, it has consequences.
Yeah, it's a good point. I mean, a lot of these attorneys are picking up our direct exam, and they're just going to read the questions, and it really does help if they have some working knowledge of what the analysis was and what we did to get there. Always better it's better for the attorney to be, as educated as possible regarding the subject matter of what we're going to be testifying to, if you can manage the time.
And oftentimes it's not so much a time issue on the attorney's part, it's the client. Maybe there's some fee sensitivity going on and everyone's getting pushed back on the fees.
Sure, that's a very real consideration.
Yeah.
Okay, and this is just what I started to talk about. I knew there was a slide coming up. We love to to have our attorneys be familiar with what we're doing, so that when we're asking for the QuickBooks file, you guys know why we want it, or whatever document we're asking for, we want you to understand why we need it, so that it's, if there's, why are you guys so focused on this one bank statement from 2.5 years ago? Well, it's because it's the only one that's missing. It's a red flag. And the language on how to request things, we told you before, we've got the language, we've got the templates, we've worked through it and made sure that it's as airtight as it can be. So,
Covered all the other
Yeah, we've already pretty much covered that. Just reading, assessing, communicate weaknesses in opposing experts' work. Yes, we do that. And understanding and explaining, like, how is that guy coming up with a business valuation that's $2 million off of yours? Well, I'll tell you, he's not considering reasonable compensation, or there's like 4 or 5 areas in business valuations that are subjective. And if there's an expert, or if there's a difference between 2 experts' business valuation, we can usually find where the difference is in about 5 minutes. So it's always, to the extent that your expert can help you understand what we're looking at, communicate with them, talk to them.
So that missing bank statement, how do you compel them to give it to you?
It's a good question. There's a way it's supposed to work when there's rules, and then there's the way it works in reality. And what we do, of course, you're going to make a supplemental document request. If they don't turn it over, your options are a motion to compel, which the attorney has to write and go argue, and it costs money. Or if obviously you're going to know the bank, you can subpoena the records, but that costs a little bit more money too. The thing the point I'm making is the courts don't like discovery disputes in family law. I mean, Allan asked for 3 years of bank statements, he gets them. We asked for 3 years of bank statements, and the judges might jump up and down and slam their fist into the desk, but the guy's not going to turn it over. He's not going to turn it over. Diane, do you have any experience with an opposing party not turning over statements and us having to testify?
All the cases.
And this particular case I'm talking about, because I was working with Diane on the case, this guy hadn't given us his retirement statements in over a year, so we don't know what's in that. And the judge told him, by God, you give them those statements or I'm going to give her everything. But he didn't. I mean, what are you going to do? Hold him in contempt? Put him in jail for a discovery dispute? No, he didn't do anything. So there we are in trial, and I'm testifying. It's like I've got a balance that's 1.5 years old. So I took like the S&P index and applied it to the balance then to estimate what it was now. And the judge was like, at the end when he was doing he just did the division from the bench, he said, well, I don't know where you got this balance. And like, you would have known if you'd been listening when I testified about it. I mean, they don't pay attention to discovery disputes. They're not going to put somebody in jail for contempt, and then they end up, we're just going to divide it up best as we can. And it's really frustrating. Is that more answer than you wanted?
I wouldn't say that.
But yeah, it's sometimes really tough. The judges don't want to hear discovery disputes, and they'll threaten, but they won't do anything. And sometimes parties to a divorce are just not going to give it up. So your best option at that point is pay the money and subpoena the bank.
Which I think is a lot of times where it goes with us. Is I'll tell the attorney, and it ceases to become my problem. The simplest level. And they're either going to go to the opposing counsel and request it, or they're just going to subpoena the bank.
Funny thing was about this, I'll go on since we got a little extra time. The opposing counsel that crossed me in this case, nice guy, didn't know what the heck he was doing. And during that line of questioning, when I was explaining that I used this S&P 500 to anticipate, estimate what this account was worth now, it was right during COVID, and the S&P had gone up 30%. And first of all, he said, well, did you apply the S&P index to your client's statements? I'm like, no, I didn't have to. She gave me the statements I needed. And then he said, he pointed out that the S&P had grown 30% in that last 1.5 years. And he said, during a pandemic, ha, 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 ha. Just laughed it off like I was, this expert is crazy. And he was wrong. It had grown 30% in a 1.5 years. But I mean, it's just, when you don't have the documentary evidence, you're just left to, it makes it much harder. And unfortunately, in family law, it's really, if somebody's not going to give it to you, the judges don't, in my opinion, do enough to enforce the discovery.
Steve, let me ask you a question. It's a little bit late, but you say you can get a bank statement directly from the bank. Now, what permission do you have to show them to do that?
It's subpoena. Anybody want to field that? I mean,
Well, I mean, if it's the opposing party that doesn't want to give up the statement, you can get it
Yeah.
without,
Yeah, I mean, these attorneys are nodding their heads. You can do it. You've got a lawsuit. You issue, it's the authority of the court. Hand over these documents.
If it's a bank with agency in Georgia, it's much harder. Right now, I have a case where we can't get statements, but it's because it's a Massachusetts bank. Federal.
Yeah?
And they don't service in the state of Georgia. Right.
I have to have an agent here.
Yeah.
Yeah. Or you can go up to Massachusetts and go to court there.
It's quite a process.
I understand. It's very difficult. Anyway, yeah. What else? Okay, we've already talked about a lot of this. When to hire as soon as possible. Why? So we have time to do our analysis and supplement requests that are frequently necessary.
Early as possible doesn't mean 2 days before trial. Just so you guys know.
And I already gave you that example of the guy that paid my retainer at 6 p.m. on a Sunday night and mediation's 9 o'clock the next morning. There's only so much I can do, you know.
We love to be as helpful as possible, but that's asking a bit much.
I feel like we're repeating ourselves here. Start early. Have we made that point? Put in the time to understand the subject matter. That's what I was talking about. Know the strengths and vulnerabilities. That comes from communicating with your expert. Pay attention to the cross-exam. Be ready to redirect. That's a little personal experience. And of course, these things may be difficult with a fee-sensitive client, as you all know.